I now recognize the ranking member, the gentleman from Mississippi, Mr. Thompson, for his opening statement.
Thank you very much, Mr. Chairman. Good morning. Before we begin today's hearing, I want to address misinformation my Republican colleagues are spreading, falsely alleging that Secretary Mayorkas is refusing to testify before this committee. Let me set the record straight. Secretary Mayorkas has testified before Congress more than any other cabinet secretary. He's appeared before this committee twice in the last year, including just 2 months ago when he testified for several hours about border security. His willingness to work with the committee has been a welcome change from the Trump administration, whose officials consistently refused to comply with congressional oversight. They ignored virtually every oversight letter and even defied a subpoena for their so-called acting secretary to appear before the committee. Secretary Mayorkas, however, has been forthright in dealing with Congress. In response to the chairman's request to testify at today's hearing on January 11th, 2024, the secretary sent a letter agreeing to make himself available to testify at a future mutually agreed upon date. However, the chairman has refused to accept. Instead, Republicans sent angry letters and tweets accusing the secretary of refusing to testify, knowing full well he said he would appear. Republicans are acting in bad faith. Unfortunately, that's nothing new. Months ago, Chairman Green promised donors at a campaign event that he'd bring an impeachment case against Secretary of Homeland Security Alejandro Mayorkas. He told his contributors to, quote, get the popcorn, and promised it's going to be fun, unquote. Before the committee had even begun its inquiry, Republicans had predetermined the outcome. But why did Republicans invite the secretary to testify only to refuse his offer to appear? The answer to that question appeared in the Hill newspaper last night. Mr. Chair, I ask unanimous consent to include in the record this article from the Hill describing how Republicans had set the date for the markup of articles of impeachment before holding the first hearing on this subject.
Without objection, so ordered.
According to an internal Republican memo dated January 10, 2024, Republicans had already scheduled a committee vote to impeach the secretary prior to holding a single impeachment hearing. Just as we've said all along, the outcome of Republicans' so-called impeachment investigation has been predetermined from the start. The chairman promised to follow the facts, but Republicans never really intended to do so. They are hurrying to adhere to an artificial timeline agreed in a backroom deal between Republican leadership, who's holding on by a thread, and its most extreme mega members. This isn't a real impeachment. It's a mega spectacle paid for by American tax dollars for Republican political gain. But through it all, Secretary Mayorkas remained committed to doing his job. The Department of Homeland Security's mission and the men and women who served with him at DHS. The Secretary is also committed to work diligently on a bipartisan basis to secure necessary funding for border security and to prepare the department for a possible shutdown. I wish my Republican colleagues would engage the Secretary to provide the department the funding it needs, but they have refused. I look forward to continuing to work with Secretary Mayorkas on critical Homeland Security issues facing the country and commend him for his unwavering commitment to duty even in the face of this sham impeachment. I also note for the record that when I asked at last week's hearing about providing the Secretary due process during the committee's impeachment proceedings, the chairman gave no substantive answers to my repeated inquiries. In fact, he seemed to have even considered providing the Secretary due process and appeared unprepared to respond. This is unfortunate, but not surprising. Again, this isn't a real impeachment. It's a predetermined, pre-planned partisan political stunt. Yesterday, the chairman threatened to hold Secretary Mayorkas in contempt for failing to appear before the committee, even though the secretary has already agreed to appear. That's not how contempt works. I can't help but wonder if Republicans are getting a bit desperate, especially after their hearing last week was a flop. It fell flat after their witnesses, 3 Republican politicians, rehashed old partisan talking points without so much as a shred of evidence to support their politically motivated claims for impeachment. The Democratic witness, respected impeachment expert and constitutional scholar, Professor Frank Bowman, testified, and I quote, "Policy differences, no matter how severe, no matter how heated, are simply not grounds for impeachment," unquote. You cannot impeach a cabinet secretary because you don't like a president's policies. That's not what impeachment is for. That's not what the Constitution says. Unfortunately, Republicans are willing to damage the Constitution they claim to hold dear because they think it will benefit them politically. Which brings us to today's hearing. I want to begin by expressing my deepest sympathies to Mrs. Noble and Mrs. Dunn on the tragic loss of your children. I cannot fathom your pain. As a father and a grandfather, my heart truly goes out to you. Indeed, our hearts go out to all those who've lost loved ones to drugs and violence, and we are committed to helping prevent future tragedies. Democrats want to strengthen border security. We want to keep fentanyl off our streets. We want to keep communities safe. We want to help those struggling with addiction. But impeachment will not do any of that. The fact is, impeachment is a waste of precious time that could be used to legislate on the urgent issues if only Republicans were willing to do. The Democratic witness today, Professor Deborah Pearlstein, is a constitutional law scholar, but in addition to her knowledge of impeachment, she's great expertise on the awesome power vested in Congress by the Constitution to effect change for the American people. That power is not through impeachment. As Professor Pearlstein stated in her testimony, and I quote, "Impeachment of Secretary Mayorkas can have no impact on the administration's exercise of immigration enforcement discretion, a power the Supreme Court has repeatedly recognized is vested by the Constitution in the executive branch," unquote. Instead, Congress' power comes from its ability to legislate. As Professor Pearlstein goes on to say, quote, "No branch of government has more power under our Constitution to address matters of border security than Congress," unquote. In other words, it's up to Congress to provide funding to interdict fentanyl, fix our broken immigration system, and provide help for those suffering from opioid addiction. That's our role in this, to use the power provided under the Constitution to legislate on important issues to help people who need it most, and not some baseless, senseless impeachment. I look forward to hearing from Professor Pearlstein about Congress's power to make meaningful progress on these and other issues. Mr. Chairman, I made this plea to you last week. It fell on deaf ears, but I'll try again. Let's drop this baseless impeachment and get back to doing the real work of securing the homeland and helping people across this great country. Before I yield back, Mr. Chairman, I have a parliamentary inquiry. I'd like to give you another chance at this one.
You're recognized.
Mr. Chairman, during our hearing last week, you said, quote, "The committee will follow the rules of the House," end quote, with regard to Secretary Mayorkas' due process. What provisions of House Rule 11 grants the Secretary representation before this committee?
Just a question of clarification on the parliamentary proceeding. What rule are you citing?
Rule 11.
Rule 11. The secretary is not appearing before the committee today, so his counsel is not necessary.
Mr. Chairman, we all know that Secretary Mayorkas has been willing to appear before this committee. He's not running from anything. He's been to the Capitol Hill 27 times since he was sworn in. My question is about due process, and there's nothing in the standing House rules that protects the Secretary's rights. So, Mr. Chairman, pursuant to Clause 2J1 of Rule 11, I'm furnishing you with a demand for a Minority Day hearing on this subject, signed by all the Democratic members of this committee.
So the demand is not proper. You have a witness present, so. Before, right?
Yeah, this is the unanimous consent that include in the record the article, but also I have this request for the,
You want this included in the record? Is that what you're asking?
well, that's a request for a Minority Day for the committee.
Okay. So as I understand the rules, the request is only in order when you don't have a witness present, and today you have a witness present, so this is not in order.
Mr. Chairman, may I make a parliamentary inquiry on that?
Yeah.
Is this an impeachment inquiry?
You want to read the request? Yeah, this is actually a hearing, not an inquiry.
Is this part of an impeachment investigation?
This is an impeachment hearing.
Okay. Under impeachment precedent, separate and apart from this particular hearing, the minority is allowed to have a hearing of its own choice and its own witnesses. That has happened in every single impeachment in history. If this is going to be an impeachment process, then there have to be rights and due process afforded to the individual who is being impeached. And part of that, historically, under historic precedent, is that there is a minority day with minority-determined witnesses, not a minority witness who's added to a hearing that the majority determines.
So I want to make clear this supposed misinformation about the request to Secretary Mayorkas. There have been multiple requests, 4 in fact, of me to ask him to come and be a part of this. And he has, to the press, said yes, to me, not provided any dates, and at some date in the future. You can't, that's stonewalling. And so at some point after 4, I finally said, I guess it was Monday, well, just send us a testimony in writing. So far, we haven't seen that either. The effort to give Secretary Mayorkas an opportunity to come before the committee in this context has been made many times. I appreciate that the ranking member pointed out that he has been in front of our committee, but that was mandated by, the threats briefing. That's what he came for, was the threats briefing, not a part of this investigation on the southwest border. Every time we've invited him, he has refused to give us a date to come. So he's been afforded an opportunity to come.
I understand that, and that's a separate issue, whether or not Mr. Mayorkas wants to take part in his own impeachment inquiry. But the question for you is that as part of the House impeachment process, there must be afforded to the minority a hearing that the minority gets to determine, because it's an impeachment process. It is not a normal oversight investigation. What Secretary Mayorkas wants to do is a separate matter. I understand your view, and I understand the ranking member has a different view. I'm sure we will get all of the different letters in the record, and I have an article here saying that the DHS letter contradicts the GOP claim that Mayorkas refused to testify, which I could enter by unanimous consent. But we're just talking right now about the impeachment process. And in this committee, where it has never been done before, it's normally in the Judiciary Committee, that there has to be a minority day with minority-determined witnesses.
I appreciate the letter, and we'll take it into consideration. And Mr. Ranking Member, you're recognized for the remainder of your opening.
Well, let me ask unanimous consent that that be included in the record. The
Without
request.
objection, so ordered.
So, Mr. Chairman, Rule 11 does not mention anything about having a minority witness at any given hearing. It only provides for a minority day. I refer the chair to page 599 of the House Rules Manual.
Were you asking a question, Mr. Ranking Member?
Yes, I mean, we didn't ask about a witness, we asked for a day.
Yes, I saw the letter. We've entered it into the record, and we want to continue with this hearing. We'll address that later.
No? Well, Mr. Chairman, this committee cannot proceed to any markup. I know you have long planned in which you committed to the speaker and to a member of this committee behind closed doors without a full hearing of the merits of impeachment. But a minority day on an impeachment is allowed by the rules.
Thank you.
And so we're just trying to,
No, I appreciate you
do
mentioning.
you plan to honor that?
We're going to take it into consideration, and I'll meet with you later to talk about it.
Well,
I mean, do you have any other comments for your opening remarks?
It's a simple request. It's in the rules, and we just want the rules to be followed.
There's an interpretation disagreement on this. Our parliamentarian says that you're entitled to witnesses and not a specific hearing. We'll take a look at it after this, and you and I can talk about it then.
Mr. Ranking Member, will you yield for a question? I just want to make sure, because I don't think it was entered into the record before. The Ranking Member referred to the letter that Council Secretary Mayorkas sent to the committee on January 11th.
If I could, Mr. Magaziner, this is his opening statement, not his 5 minutes. He can yield time to you in his 5 minutes.
Okay, I was just going to ask unanimous consent that the letter be entered into the record, but
I'm fine with that. We'll break protocol here just a second. If there's no objection, so ordered. Mr. Ranking Member, you're recognized still.